When you sign an arbitration agreement with your employer, you're agreeing to let a private arbitrator settle disputes instead of going to court. But what happens if that arbitrator rules against you and orders you to pay thousands of dollars? Can your employer simply walk away from the federal court system entirely? The Supreme Court just said no. In a unanimous decision, the justices ruled that federal courts keep the power to review arbitration awards even after sending a case to private arbitration. For workers like Adrian Jules, who lost his job and his arbitration case, this decision means courts can still check whether the arbitration process was fair. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Adrian Jules worked at the Chateau Marmont Hotel in Los Angeles from 2017 to 2020. When he was fired, he sued in federal court in New York, claiming the hotel discriminated against him. But the hotel pointed to an arbitration agreement Jules had signed when he was hired. This agreement said disputes had to be settled by a private arbitrator, not in court. The federal judge agreed and paused the lawsuit while Jules went through arbitration instead. Jules lost every claim in arbitration. Worse, the arbitrator ordered him to pay about $34,500 in penalties. When the hotel asked the federal court to officially confirm this award, Jules fought back. He argued the court no longer had any power to act because the case had been sent to arbitration. The trial court and appeals court disagreed and sided with the hotel. The Supreme Court took the case to settle confusion among lower courts about what happens after arbitration ends. Jules pointed to a prior Supreme Court decision that said federal courts cannot simply assume authority over arbitration awards without a solid legal foundation. He argued this rule should apply no matter what, meaning every request to confirm or reject an arbitration award needs its own independent reason for a federal court to get involved. The hotel made a simpler argument. The federal court never actually lost power over Jules's case. Pausing a lawsuit for arbitration is not the same as dismissing it. The court kept the case on its docket specifically so it could oversee the entire process, including what happens after the arbitrator rules. The hotel was just asking that same court to finish the job. Justice Sotomayor wrote the opinion, and all 9 justices agreed. When a federal court pauses a lawsuit to send it to arbitration, the court keeps its authority to review the arbitration award afterward. The reasoning is straightforward. If a court has power to decide a case, it has power to handle motions and decisions within that case. The court explained that Jules's situation was different from the prior case he relied on. In that earlier case, someone walked into federal court for the first time asking to confirm an arbitration award with no existing lawsuit behind it. Here, Jules had already filed a federal discrimination lawsuit. That original lawsuit gave the court a solid foundation for its authority. The pause button did not erase that foundation. The court also noted that federal law requires courts to pause cases for arbitration rather than dismiss them. The whole point of that rule is to let courts keep watch over the process. If Jules had won his argument, courts would have lost that oversight power in cases involving federal law, which is exactly where federal court involvement matters most. This decision creates a logical flow. You file a federal lawsuit, the court pauses it for arbitration happens, and then the same court confirms or rejects the award and enters a final judgment. Everything stays in one court system with one appeals process. Jules's approach would have split things into separate proceedings in state and federal court, risking contradictory rulings. For example, a state court might confirm an award on claims that a federal appeals court later decided should never have gone to arbitration in the first place. The court also clarified that an arbitration award functions like a legal defense to your original claims. When a court confirms it, the award becomes a binding judgment with the same weight as any other court ruling. This means requests to confirm or reject an award are not separate legal actions. They are part of resolving the lawsuit that was already before the court. If you sign an arbitration agreement with your employer and lose your case, you cannot simply hope the company walks away. Federal courts will still have the power to review whether the arbitration award should stand. This decision preserves an important safeguard. Even in arbitration, the federal court system maintains oversight. You get a private arbitrator to hear your case, but you do not lose access to court review of the final result. That balance between respecting arbitration agreements and protecting workers' rights is what the Supreme Court protected here. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.